Well, first of all, they should try mediation or the collaborative process to try and resolve their difficulties. That's certainly what I would recommend and is generally better for the children when it can work. But it can't always work, and then the option is to make an application to court. Now, what that application is for will depend on the issues between you. It could be for a residence order, which will deal with where the children should live. It could be a contact order, which is about how much time the children spend with the parent with whom they don't have their main home. It could be for a specific issue order about a particular aspect of their upbringing, their education, for example, or a prohibited steps order to stop the other parent doing something like, say, changing their name. You might also need to apply for a parental responsibility order if you don't automatically have parental responsibility.
And so what do I need to do to make an application to court?
Well, the first stage in most cases is to attend a MIAM, a Mediation Information and Assessment meeting. And that's a meeting with a mediator. And a mediator will explain to you all the possible processes you could use to try to resolve your dispute. And at the end of that process, you'll be given the form FM1 that you need to take to court together with your application for the order to get that application issued. You'll need to pay a fee, and then the court will then list a short court appointment, usually about 4 weeks later, a first directions appointment in effect. During that time, safeguarding checks will be carried out by a CAFCASS officer, and then at that hearing the judge will see whether he or she can help you to resolve the dispute between you, or at least to narrow the issues. If it isn't possible to get a resolution at that hearing, then the judge will list another hearing and will make any directions that are necessary, for example, about gathering evidence together to help the judge be able to make a decision at the final hearing.
From start to finish, how long do you expect the process to actually take?
That really does depend on the circumstances, and very often in practice what happens is that there are numerous short court appointments when the judge tries to work through it all to find a consensual solution, which will be better ultimately for the children and for the family. But if it's urgent, the judge can make an order on the same day if that's necessary to protect the children, and the court has a duty not to cause unnecessary delay.
So what exactly does the court take into account when it's deciding to make one of these orders?
The children's welfare is the paramount overarching consideration, so that is the most important aspect. But beyond that, the court has to consider what's called the welfare checklist, and that list includes things like the children's wishes and feelings, as is appropriate to their age and understanding, also their needs, their physical, their emotional, their practical needs, and also the ability of the parents to meet those needs in whatever way. Their children's personal characteristics are relevant, as is any harm or risk of harm to them, and also the effect of any change in the circumstances as they are now on them. So the court will take all of that into consideration and will also be helped by any expert evidence and a report of the CAFCASS officer when making a decision at the hearing.